Beautiful people, welcome back. Motion to dismiss. Motion to dismiss is all that is needed to kill any claim that you bring in, whether it's civil or criminal, whether it involves human life, properties, effects, or it's just other matters that you bring in just for the heck of doing it. Whether it involves monetary interests or otherwise, whether it's in personam or in rem, in personam being a personal capacity or rem being a property or something that's not based on personal jurisdiction. All that is needed to basically throw that complaint of yours that you're bringing it as a form of restitution into the trash is something very simple called a motion to dismiss. And that motion to dismiss, on the other end of the party that's bringing it to say, hey, see, this guy had failed to state a claim upon which relief can be granted. So go ahead and throw his complaint to the trash. All they're doing is just making reference to your complaint and nitpicking it and poking at it and saying, look, this line is trash. This line is trash. There's nothing here. And in some cases, they don't even do that. They don't rebut it line for line. They just smack you with a very simple standard. The standard is based on two-pronged. And then there's another thing called fair notice. And then there's another thing called the requirements of survival. A motion to dismiss is considered the phase whereby they determine whether your complaint belongs to the dead man's grave or not. And the good part about that is when you survive that motion to dismiss stage, which 9 out of 10 times will be the first thing they will slap you with, even if they intend to settle. Because you have to prove that your documents are well pleaded. See, there are two main ways that one can show that their documents are well pleaded. The first is the succinct nature and the clear language within your complaint itself. The second is how you respond to the motion to dismiss. Because through the way you respond to the motion to dismiss, you can actually kill their claims if you know what you're doing and make yours stronger. See, education should excite people. Education is so great that it should make you excited. Most people who go to the formality of colonial systems, they get excited when they graduate college or high school. But the reason they get excited is because they're leaving somewhere. Education has been turned into a task within the formal school system. So when those students leave those formal school system, they're happy that they're getting away from the boring task of taking a test, studying, waking up, going to school, this and that. That is the reason why students get excited when they graduate. They're not excited because they're going somewhere, because believe it or not, most of those students actually don't know where they're going unless your parents have set up some type of organization or has set you up with a different education outside of what the everyday graduating class is going through. Then you'll be excited where you're going. But the normal average student in a formal school system is excited about graduating high school or college, either with master's, bachelor's, or doctorate, because they're tired of the education that they're getting, the formality of it that's boring. It's a task. But in truth, you should be excited about where you're going when it comes to education rather than where you're leaving. The former school education system has turned the love for study that one should always be excited about. They've turned it into a task, into a liability, into a burden. This is the reason why a majority of people who have gone to any type of education system, they don't functionally use the information they've accumulated. See, with things of this nature that we speak of here on YouTube platform, or on Patreon, or on Facebook, or on Instagram, it should excite you because you've graduated one aspect of things, and what you've graduated will be what you will use in where you're going. Because education broadens one's awareness or one's perception. When you're properly educated, you see the world from a different perspective. You see the world from a bird's eye view. That alone should excite you. Because where most people will fall victim for certain things within the so-called system that everyone blames, where the majority of those people will fall victim to it, that education that you've accumulated would excite you because you know that blockade people face, it's just nothing more than something you just hop over and casually go on about. It's nothing. What people see as an obstacle, you see it as an opportunity. Because all obstacles are just nothing but something that's there to tell you you probably should do something differently. But you have educated yourself beforehand that when you see certain things, you know exactly what you ought to do differently, rather than stay stuck and go, oh crap, what do I do? Or you get upset and say, they're fraud, they're bad, they're doing this. Save that for the birds, because you know better and you do better. Education is what will guide that passion. Merely claiming that you're passionate about something or merely actually being passionate is not enough. In this game of life, having passion alone by itself will get you, for the lack of a better term, fucked up. You need education paired with your passion, because the education is what's going to guide that fire called passion. It's going to help you get where you need to get. Otherwise, that passion will burn you up. You would exhaust yourself, when in truth, you're supposed to retain a lot and gain some more by virtue of the education that you have. And this same education is what assists you accomplish what you are meant to do here on earth. A lot of people go on about what are we here to do on earth, so and so. Part of that main thing you're here to do on earth, regardless of who you are, where you're born, who you think you are, or who you think you're affiliated with, part of what you are meant to do is to educate yourself about how the world around you works. And too many people in North America fall victim to this so-called system. Especially, see, the man who tries to take a step towards freeing themselves go through more anguish than the man who does not do anything in saving himself. Because it has to be that way. When you begin to try to remove any type of encumbrance in your life, it is necessary for the other party benefiting from it to press down harder on you, to discourage you. And the only way that can be successful in their end, based on their mode of operation, is if you are not properly educated. Merely having passion instilled and asserted into you about what someone does, being bad or good, is not enough. You need to be educated. And part of it is knowing what they do and the standard behind why they say what they say that might go over your head when they're saying it. In this case, when you try to bring restitution, just one simple tool is required to kill all of it, even if what you're saying is valid. This little stuff everyone goes through every day, in everyday life, is nothing more but just another form of the same thing that we're all supposed to do in a totality. You and I came on this earth to learn to do better, no matter what form it takes. Once you've learned to do better, then you will probably start to think on other levels where you'll consider, do I really want to come back to this earth? This earth thing is, I don't know if you've put it into consideration as of yet. The concept of reincarnation, whether you believe it or not, coming back to earth in a different body, probably similar family, similar part of the world, whatever it is, whatever you understand of reincarnation, you keep doing that because you failed to learn something in your previous lifetime. Just as much as if you fail to learn something during a certain stage of things and you keep repeating it, you keep repeating over and over, and you keep failing and you keep doing the same thing. There's a bigger picture when it comes to life. You don't want to keep coming back here. You want to get done what you need to get done on earth and go to better and higher places. You want to get the fuck out of here. Earth is like a prison for mischiefs, and people who have screwed up on a cosmic level keep coming back until they learn better. And guess what? That earth system on a spiritual cosmic level is shown to you in your everyday life through your everyday experience, such as the quote, the system that everyone goes about, the system kicking everyone's butt. Well, learn about it so that you can do better, so that you can stop being victim to it, repeating the same grade of victimhood over and over and over and over. It's not as complicated as what might make it appear. It's far simpler. And all it takes is just a time to care for it. By care for it, you care for yourself. Again, all it takes to remove any claim you're bringing, whether you are making a constitutional claim, statutory claim, whatever it is you're doing, all it takes to kill your claim is one very simple tool called a motion to dismiss. And once you comprehend this stage of what they do, you'll graduate past that. There's so much more. There's so many stages to these things. But you have to graduate past this rudimentary stuff. Most people that you would hear of speaking about doing one process or the other don't know that there are standards to how they come at you. They're fixed algorithms. Know that there are standards to how they come at you. They're fixed algorithms. Know that there are standards to how they come at you. They're fixed algorithms. Know that there are standards to how they come at you. They're fixed algorithms. Know that there are standards to how they come at you. They're fixed algorithms. If you don't know that, then you're walking in blindly into a battlefield. Don't do that. Know what's going on before you step into it. And the thing is, these algorithms that they're fixed by, they will try to regurgitate its statements just like most people who say they have rights do, but they actually don't function within the confines of those statements itself. That is where you catch them. That is where you chop it off at the knee. And when you listen to videos like this, don't listen to it with the formality of the state of mind like you're going to school. Be free with it. Pause it. Think about it. Do some self-reflection. Be creative with your thinking when you listen to these things, and see the totality of it as it applies to any given circumstance. Because no matter what you're dealing with, if you're dealing with child support, if you're dealing with a traffic ticket, if you're dealing with a criminal supposition of whatever it is, firearm, mortgage, this is the same algorithm that is required within a motion to dismiss, no matter what the subject matter is. The algorithm is the exact same thing. That should make it easier on your end and difficult for them. Yet, most people, because they don't know this simple algorithm, it's so difficult for them. And all they can blame at the end of the day is, quote, the system. When in truth, the system is so limited that all you have to do is be aware of it. Awareness, you have to be aware of it. The first res judicata we're going to go over is the DeSabio versus Home Medica Ostenics Court. Case number 09-CV-287S. September 11, 2011 is the day decision was made. We're going to cut straight to the chase and to the core of everything. To survive a motion to dismiss, a complaint must contain sufficient factual matter. Meaning, a motion to dismiss is all it takes to kill your complaint. And the moment a motion to dismiss is placed into the equation, your complaint is in survival mode. Meaning, it's not guaranteed for you to succeed with that thing that you're bringing in against them. Hence, to survive a motion to dismiss, a complaint must contain sufficient factual matter, accepted as true, to, quote, state a claim to relief that is plausible on its face. Plausible on its face refers to prima facie evidence rather than substantial evidence. Labels, conclusions, or a formulaic recitation of the elements of a cause of action will not do. This is what a lot of people do. Merely saying that you've violated my right to this, you violated my right to that, is not enough. This formulaic recitation of the elements of a cause of action that will not do is what many people do in fact. What you have to do is you have to show the context, the specific circumstance, based on the rules of evidence. Facial plausibility is present when the factual content of the complaint allows for a reasonable inference that the defendant is liable for the misconduct alleged. You know what the reasonable inference is? The reasonable inference is the context of how and why, again, of how and why you are saying that a right is violated. The mere formulaic recitation is the what, meaning what has happened. My rights have been violated. The reasonable inference is how and why it occurred. Why does what you're saying apply as a violation of right? Why are you entitled to redress and grievance according to the First Amendment? That is a reasonable inference. You have to show the context. So merely stating res judicata's, merely citing case laws is what they consider as labels, conclusion, or formulaic recitation. Meaning you have to demonstrate competency, and if you don't do it, it's just a label, it's just a conclusion, it's just a recitation. In other words, you're just regurgitating something. They don't care about that. Your complaint will not survive a motion to dismiss if you're doing that. Facial plausibility is present. And then what makes your complaint plausible on its face? Facial plausibility is present when the factual content of the complaint allows for reasonable inference that the defendant is liable for the misconduct alleged. The plausibility standard. Now we're going into the standard of what makes a complaint plausible. If you're going to sue anyone, you have to make sure it's plausible anyway. In other words, if you don't know what this standard, aka the plausibility standard, if you don't know what it is and you don't implement it into your complaint, you're going into a battlefield blind. This is where the importance of education before doing something comes in. This is what makes a difference between those who cry, whine, and complain, and those who do things successfully and keep quiet about it, or tell others about it, that look, you can do this too. The plausibility standard is not, however, a probability requirement, probable cause. The pleadant must show, not merely allege, that the pleadant is entitled to relief. Again, you can't just say, hey, this guy did this and he did that, and because of that, I'm entitled to this. You have to show why and how. You have to show the context, the details of it. If you're saying someone, for instance, performed assault and battery, contrary to a lot of people's presumption, assault and battery does not necessarily involve physical contact. Assault and battery can involve the apprehension of you feeling like you're in danger, believe it or not. That's part of the language of the elements of what assault and battery is. So instead of you saying there was a reasonable apprehension of you being in danger, or that someone intentionally or willfully or negligently or maliciously did this, instead of just making those buzzword allegations, the recitation of it, what you're going to do is you're going to express word for word, either because of the audio that you've been making reference to, that you've recorded an interaction, or you would explain exactly how you were put into reasonable apprehension of danger because the man or woman used unreasonable force and dragged you. Or if you're saying, well, these people didn't have the right to even foreclose on a property because the deed was not even supposed to be registered in the first instance in the public, and there's no way that consideration can be given according to the National Bank Act with this mortgage situation because bank have no asset to lend out, and there's no way that I would have been able to be liable for this mortgage because the house is being used as a collateral for the mortgage, and the only way I can use the house for collateral is if I already own it. You can't use something as a collateral if you don't own it. And you show that there's an interest of trust relationship because the property was owned by a trust. If you're saying someone cannot bring criminal charges against you, you go through the details of all that, of the why and how, not just say that this happened, that happened, and I don't agree with it and they don't have jurisdiction. That's not enough. That's just mere recitation. You have to show, not merely allege, that you are entitled to relief. Well-pleaded allegations in the complaint must nudge the claim across the line from conceivable to plausible. A two-pronged approach is thus used to examine the sufficiency of a complaint, meaning now there are two parts they use to determine whether the complaint is sufficient. This is what is in the eyes of the acting judge anytime they look at a complaint. This two-pronged approach is what is in the eyes of any law clerk who works under any acting judge when they look at any complaint. This is what is in the eyes of any attorney, on the other hand, looking to botch your complaint to make it look like it's irrelevant. This two-pronged approach is the foundation that they will build their motion to dismiss to kick your butt. A two-pronged approach is thus used to examine the sufficiency of a complaint. In other words, you, the one constructing the complaint, must know what this two-pronged approach is in order for you to structure around it, or for you to use it as the structure of the complaint, or for the purpose of meeting the end of the complaint. First, statements that are not entitled to the assumption of truth, such as conclusory allegation, labels, and legal conclusion. You know what legal conclusions are? Citing res judicata, trying to sound like an attorney. Attorneys can cite res judicata because they have a hold harmless agreement with that court called the bar membership. So they have that prestige as an officer of the court to do that. You don't. So you cannot make legal conclusions. You have to show how your specific instance qualifies as in that claim. They call it being well pleaded. When you plead your matter well, you're showing the why and how rather than the what. That's what all this is basically telling you. First, the statement that are not entitled to the presumption of truth, which is you just reciting things over and over. Conclusory allegations, labels, and legal conclusions are identified and stripped away. Second, well-pleaded, non-conclusory factual allegations are presumed true and examined to determine whether they plausibly give rise to the entitlement to relief. The only reason why they will begin to examine it if they see that it's not just generalized based on some other people's circumstance, such as you citing a res judicata, that, well, Miranda versus Arizona or Erie versus Tonkin or whatever it is people cite in their case laws. You have to show your specific instance and break it down as to why and how it violates any given right that you say that you have. In other words, the why and the how is far more important than the what, because the why and the how is what's going to be used to determine the validity of your claim. And the why and the how is a two-pronged approach. Independent of all these legalese, the why and the how is a two-pronged approach. And if you cannot express the why and the how in black and white, you might as well not file that complaint. You might as well not attempt to state a claim in any way, shape, or form. Your act of saying you have a right or that someone has violated a right is the what, but how it was done is the only way due process can be afforded. And that is the plausibility. That is what makes your claim plausible. And it is incumbent upon you to show the why and the how. And usually, whenever they do a motion to dismiss, they do it based on two specific rules within the Federal Rules of Civil Procedure. Rule 8 and Rule 12. Rule 8 tells you it has to be done simply and it has to get to the point. So whenever you're doing it simply and you're trying to get to the point, forget about the what. Get straight to the point of why and how. Simple as that. And Rule 12b6 lists the details of how they can say that you have stated no claim. In other videos, we've went over that. Another case that we're going to go over that goes into details specifically as to what you're saying when it comes to the what is irrelevant. Supreme Court of the United States. Ashcroft, former Attorney General, amongst others, versus Iqbal. amongst others. Case number 07-1015. The fourth section tells you, we turn to Respondents Complaint on the Federal Rules of Civil Procedure 8A2. A pleading must contain, quote, a short and plain statement of the claim showing that the pleader is entitled to relief. As the court held, the pleading standard Rule 8 announces does not require a detailed factual allegation, meaning you don't have to be long-winded, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. When you read the majority of people's complaint, they're basically always going to say, well, this guy did this to me, and because of that, he owes me this. And that's what they mean when they say that in order for you to survive Rule 8, you must do more than provide an unadorned, the defendant unlawfully harmed me accusation. In other words, you have to show the why and how. And on that same note, the third res judicata, Swerkiewicz versus Sorman. Case number 00-1853, Supreme Court of the United States. The importance of why and how over the what. Such a statement being the short and plain statement of a claim showing, the showing here, once more, is the why and how. The only way you can show anything is the why and how. A short and plain statement of the claim showing that the pleader is entitled to relief. Such a statement must simply give the defendant fair notice of what the plaintiff's claim is and the ground upon which it rests. The ground upon which it rests is the why and how. Merely saying someone did this to you is not sufficient. And if your why and how is based on some speculation of something you read online in some PDF, you are screwed. Applying the relevant standard, petitioner's complaint easily satisfies the requirements of Rule 8A because it gives respondents fair notice, meaning the moment that you show the why and how, it is considered a fair notice. Everyone knows that you give notices, right? But have whoever told you about giving notices told you what constitutes a notice and how that notice can have a standing? It's the why and how. And most importantly, to keep it simple. And when that's done, you've given fair notice. Fair being a due process aspect. Because it gives respondents fair notice of the basis for petitioner's claim. Petitioner alleged that he had been terminated on account of his national origin in violation of Title VII and on account of his age in violation of the ADAE. His complaint detailed the event leading to his termination, provided relevant dates. Look at that. I mean, this guy is saying something about, okay, the termination of my capacity with this contractor occurred. Why? Because of my national origin and age. And then he detailed the events, meaning he explained the why and the how leading to his termination, provided relevant dates, and included the ages and nationalities of at least some of the relevant persons involved in his termination. In other words, whatever subject matter you're dealing with, you have to be specific to it. You have to deal with it. Don't talk about some other stuff on some other end, such as some silver bullion about in a case, and you're saying, well, unless you provide me your oath of office and delegation of authority, you can't do this and do that. Yet you are the plaintiff in the case. What does that have to do with you holding someone liable? When in truth, what you're supposed to do is bring in that oath of office and say, now do this, rather than holding yourself back. Instead of going straight to the point of why you were bringing a claim as a complainant, as a plaintiff. Deal with the details, the why and how of the subject matter. These allegations give respondent fair notice of what petitioner's claims are. Petitioner's claims are, and the grounds upon which they rest. You have to be specific to the subject matter. So whatever it is that you're claiming, if you don't know the standard element in test, how can you specify the standard element in test relating to that specific date and time of when that occurred to you, and say this is the why and how of my claim, and thus I'm entitled to relief, rather than just merely saying someone maliciously did this to you? It's not enough. And how you feel about it should be thrown out the window, because they will probe for that. They will look for you inserting your feelings, and they will capitalize on that. And when they capitalize on that, you will respond to it accordingly, and you will fail to focus on the matter at hand, and they'll kick your ass. Believe it or not, it's that simple. For a motion to dismiss to be survived, you have to focus on the why and how of what happened. Forget the what. Forget the who's fraud, who did this, how are they fraud? Why is the situation fraud? Focus on that, and you will survive a motion to dismiss. Until next time, take care. Best of luck. Hey, beautiful people. I'm inviting you to come join my Patreon page. We speak about everything we don't speak of here on YouTube. On the Patreon page, we speak of establishing privacy in many different means, how to hold tortfeasors liable, the different types of discharge, and the steps to actually do it. Now I'll be showing my own proof of the success, the intricacies involved in why and how it works, and the things no one else would tell you because they've never discharged themselves. The intricacies of settlements, suing people, and many other basic things like other tools that you can use privately, things of spiritual nature, because this goes beyond what you observe with your five senses. And if you just want to limit your remedy to just what you observe with your five senses, think again, because the other side is not playing in that realm. It's not an even playing field. Other things like study tools are shown, things regarding trust and asset protection, and how to layer trust properly the way people seek it, and the advantage of how to do it. Banking, the functionality of how they function, and the validity of it that a lot of people misuse or are misled by, where they think, oh, these other guys are bad, so now I have to just go into argument mode. No, you don't always have to argue. The law is perfected for your benefit if you're competent about it. Many things regarding child support, different examples of settlement checks, and the videos on it, the different aspect of how you can broaden your mind internationally beyond the little chicken scraps that people are picking up when it comes to passport and things of that nature, how banking work, how property protection work, the details of copyright, tort, privacy, different types of trust, the intricacies, and exactly why and how they are done, the intricacies that people from other part of the world know about trust that you don't. Just because you read something on social media and whatnot doesn't mean you really got it. The intricacies of how to use certain jurisdiction and the stuff everyone speaks of. More in child support, more in trust, more in court, more in spiritual nature of things, etc., etc. The fact that tax avoidance is different from tax evasion. The importance of things in commerce and how to actually function in commerce. How to actually really do things as a natural person is beyond speculation. But let me give you this caveat. If you're looking for a cookie cutter or some quick fast food way, this is not it for you, either here on YouTube or on Patreon. But if you're serious about your education and the function and application of it, rather than a mere accumulation of information, then come on over on Patreon. There are things we speak about over there that are universally and exponentially beneficial compared to that of the ones we speak of on YouTube. And more importantly, the practicality and the actual use of it. Take care. Best of luck.